Vacancy Legal Recruitment, a refreshingly unique and personal talent agency developed specifically for legal. Dedicated to the sector and with extensive experience working across legal services and legal technology, we bridge the gap between your requirements and top-tier legal talent. Get in touch today and say hello at vacancy.co.uk.
You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at todayswillsandprobate.co.uk and follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Wills and Probate podcast. Today we're going to review the case of Addison and Niaz, a case that has implications for Larke and Nugus requests, so well worth a listen in. I have the firm involved in the case, Forbes Solicitors, on the podcast with me, and representing the firm we've got Lucy Scourfield, an associate in the contentious team, Shannon Thompson, a non-contentious practitioner, and barrister Norman Lamb from 9 Chambers. Great to have you all on the podcast. Thank you for joining. In the first instance, it would be great to hear about who you are and what you do, please.
So, hi there, I'm Lucy Scourfield. As David says, I'm an associate in the contentious trust and probate team here at Forbes, and we take instructions from consumers when they're looking at challenging the validity of a will, bringing inheritance claims, looking at trust disputes, tolata matters, and we pride ourselves on giving a great service.
Hi, I'm Shannon Thompson. I'm a solicitor in the Wills, Trust and Probate Department here at Forbes, so I predominantly deal with will drafting, probate administration and also trust administration.
Hello, my name is Norman Lamb. I'm a barrister at 9 Chambers, specialising in wills, trusts and contentious probate matters.
I like it when people keep the introduction brief. Thank you. Gives us plenty of time to get into the meat of the discussion, which is this case, Addison and Niaz, a case that has implications for Larke and Nugus. Lucy, can you give us a synopsis of the background to the case and take us up to kind of the point at which the decisions are being made?
In Addison and Niaz, the applicants, so they were our clients, sought a summons under Section 122 of the Senior Courts Act 1981 to compel the respondent, who in this case the will draftsman, Miss Niaz, who had drafted a will for the deceased, to attend court for questioning. This action followed a Larke and Nugus request for information from us regarding the will. After a lot of delay, we did finally get an initial response, but it wasn't adequate. We continued with the application and we let the court know about the inadequate response. We were allowed to continue and the court eventually did rule in our favour, ordering the respondent to pay our costs personally. Obviously, it just reflects the necessity of the summons and the shortcomings in her initial disclosures.
And Norman, this is really all around the speed at which the respondent failed ultimately to provide that information.
Just taking it back to the start when Forbes became involved, I think naturally as part of their investigations for a substantive claim in the background, they reached out to the will draftsperson, the respondent. She was a solicitor and draftsperson to a 2021 will. She also witnessed its signing by the deceased. A little chronology on the request made, I think, is important. I think Forbes first sent their Larke and Nugus request back in March 2023. There was multiple chases after that. There was an eventual response several months later, but that was poor. In October 23, the probate registry issued an order for the respondent to formally respond, and that was a subpoena which we had applied for by way of an affidavit to the district probate registry. And in July 24, matters culminated in the High Court in the issuing of a summons pursuant to Section 122 of the Senior Courts Act.
And Forbes were involved really quite early on in the case as well, Lucy.
Yeah, so we were instructed initially to assess the merits of an action to challenge the validity of the deceased's last will. So the deceased had 4 children. He'd left his last will appointing 2 of his children as executors and leaving his estate to be split equally between the 4 children. Our clients, so the other 2 children, wanted to prove a previous will where they were appointed executors. Unusually on this one, the distribution remained the same in both wills, so it was between the 4 of them. The dispute was as to who would be the executors. So when assessing the validity of a will, The courts look at totality of evidence when it comes to making a decision, including medical records and testimony that, witnesses of fact can give. However, in our initial case assessment, a key data point is the contents of the will draftsperson's file and the testimony that they can give. So accordingly, when we're investigating the merits of a claim, one step we always take, as we did in this one, is to send off the Larke and Nugus request and carefully consider any response when considering the merits of, our client's case. I think a takeaway point is it's not a personal attack on the draftsperson. We just want to see what's gone on. Even if they don't have capacity or there was undue influence, that's still not the draftsperson's fault, obviously, unless there's been negligence. It's just part of our assessment in order to provide prospects and merits to the client.
On the face of it, this particular case actually is quite straightforward. Why do you think it has kind of gathered the attention that it has and got to the point that it has to in terms of the profile that it's subsequently received in the press?
Yes, I think when you look at the judgment itself, Chief Master Schumann's warnings and the court's cost decision, they're obviously the principal reasons why the judgment has gained a lot of attention. And again, when looking at the judgment, it's brief, no doubt because it was a rare, unusual hearing. It only featured my cross-examination of Miss Niaz. For example, there was no trial or findings of fact made. But within the judgment, the Chief Master highlighted the inconsistencies between the respondent's response to the Larke and Nugus request and the contents of her witness statement, and those were only explained further during my cross-examination. The court ultimately found the applicants had adopted the correct approach. It was proper for us to have made this Section 122 application and to have pushed it through to request attendance for cross-examination. And it's in those circumstances the High Court ordered the respondent, a solicitor, to pay those applicants' costs personally.
And you've touched, Lucy, on some of the lessons that we can really learn from this particular case. And listeners to the podcast generally are practitioners, some of whom will be contentious, but equally quite a number of whom will be non-contentious as well. And I'm very keen that through the podcast there's kind of that education piece around, okay, what could we do differently? What could we make sure that as an organisation we're more tuned into? I think the point you made about Larke versus Nugus requests feeling quite personal is quite important. And you're right, this is a legal process, not a personal attack.
One of the key lessons is trying not to delay your response. It's not personal. We're not coming for you. We just want to see what's gone on in that preparation. Shannon will come on later about, good file handling, good note keeping, contemporaneous notes. If you provide that information to us, it's going to help us as contentious lawyers. It's an essential tool, your request, for understanding the circumstances surrounding the preparation of a will. It provides us with information about how the will was drafted, the recollection of discussions with the testator, and whether there were any concerns about capacity or undue influence. So it's essential we receive a proper and timely Larke and Nugus response. If you refuse to respond or the response is inadequate, this is the case that shows that we and other firms will pursue it further. It is difficult because there is no guidelines about responding and the timings, but, be reasonable. We've got a case to push as well. And under the Law Society guidelines, you can, charge a reasonable fee. So you're not doing it for free. You can present an invoice to us in order to provide that request and the file of papers. But it's just a warning in this case that if you don't do that, you could have a personal liability against you, or at least the firm, with professional indemnity insurers becoming involved.
I should add, in terms of best practice, paragraph 8 of the judgment describes how Larke and Nugus requests are designed to provide pre-claim disclosure and avoid legal costs being wasted in potentially futile litigation. And Chief Master Schumann referred to the Law Society issuing practice notes from time to time, setting out that best practice, which I would pay particular attention to. The court then went on in judgment to state where a request is made, the solicitor should disclose information about the circumstances surrounding the preparation and execution of a disputed will. That information should be provided to anyone who has an interest in the dispute, although arguably the class of people making the request might be wider. If the solicitor fails to respond, they may be subject to a cost order, regardless of whether the will is held to be valid or not. Answering such a request may go into privileged or confidential matters, and it is good practice to obtain the executor's consent.
Yeah, so I'm going to speak from a private client non-contentious perspective. So as a private client solicitor, in line with the privilege being a fundamental principle that protects confidential communications between the client and ourselves from being disclosed without consent, the privilege principle encourages open and honest discussions between ourselves and clients when taking down instructions. With regards to Larke and Nugus, the court ruled that discussions with solicitors aimed at obtaining legal advice are confidential and are not subject to disclosure. So this privilege extends after the client's death, particularly when it comes to communications relating to the will instructions. The authority for that privilege response passes to the executor or the personal reps of the deceased estate, and the SRA's Code of Conduct on Confidentiality and Disclosure reinforces that the contents of the will and the will file remains confidential, and the release of this information without authority is considered a breach of the SRA's Code of Conduct. So from a private client perspective, in most cases, we would always encourage our clients, who may be the executors, to give us the authority to release the information that's requested in the Larke and Nugus and waiver the privilege. Now, obviously, in some cases whereby we don't get that authority, we would then need to pass it over to the contentious probate team. We would still try to provide a response, but we would have to do so without releasing privileged information to protect ourselves. As obviously you've seen in this case, you can be held responsible if you don't provide an adequate response. And we do want to, prevent any costs being sought against us. So as a proactive alternative, we would refer it to contentious to pick it up.
You've spoken there about the SRA regulations. What about Larke versus Nugus requests for unregulated professionals? Because they're not governed by the SRA regulations. Is there anything that we can take away from this case in regards to that? I don't suppose it covered that particularly, did it?
Well, no, but from my perspective, who has, like you say, executors on files aren't, not all of them are solicitors, so they would be encouraged. It's very rare that they would not agree to it because they don't like the idea of it being held against them. I mean, I've never come across a case personally where an executor's been resistant for us to provide the necessary response. From our perspective, we always encourage that they do provide it as promptly and timely as possible. Follows on to how important our files are, because these requests can come in 10 years later. We have to make sure that our files are thorough as possible to assist in providing the response.
Yeah, because we accept that you can't remember every client. Yeah. So you've got a detailed note from the time. That's what you're going to use if you're this person stood up in court, like in our case. If you do stand up in court and paint a picture to portray that you do remember this client because your contemporaneous notes are a little bit short and lacking, then obviously we can take what adverse inferences we will from that.
Just picking up from Shannon's comment then, I think there's often going to be times where you have a solicitor draftsperson and they're stuck between a rock and a hard place. They receive a Larke and Nugus request and want to respond properly, but they're not being permitted to by the executors, or their consent is being withheld. And I think it has to be common ground that a key thing a solicitor could do in that situation is just write back stating exactly that. I want to disclose, but I'm being prevented from doing so. And I say there's an elephant in the room in this because when we look at the judgment, it doesn't address spot on what should happen in that situation. If we recall paragraph 8 of the judgment, it states where a request is made, the solicitor should disclose information about circumstances surrounding the preparation and execution of a disputed will. The use of the words should disclose could be taken to read as if a response should be given regardless. And interestingly, the words good practice also indicate that prior consent is not an absolute requirement. The judgment suggests, in the Chief Master's view, a solicitor should respond even after a failed attempt to obtain consent. And I think that puts practitioners in a really difficult position. They're looking at compliance versus confidentiality. Perhaps then just stepping back and thinking about practically what could be the best next steps. Responding firstly with, I want to respond, but personal representative won't give their consent. I think it would then be interesting to see what the other side have to say in response to that. Because in those circumstances, what you're ultimately trying to do is show as much compliance as possible and not have the risk of an adverse cost order against you. And I think at the same time, notifying the personal representatives that a response will still have to be given, notwithstanding their withholding of consent. That's a question which is going to be a difficult one for practitioners to deal with.
Ultimately, as practitioners, we have to protect ourselves and protect our businesses. The other door here is advising the personal representative that they could become liable for that costs order rather than you as an individual or as a firm.
Yes, that's right.
There's so many podcasts that I do where contemporaneous notes is kind of the key to the discussion, the nub of the issue. We simply cannot, and I've had contentious practitioners on, I've had barristers on, and I've had non-contentious practitioners on who, to a man, have all said you cannot overstate the importance of having good, thorough, proper notes.
And especially with recent case law, the courts will put a lot of weight on the solicitor's evidence. You know, it's all well and good getting an expert report after medical records, but all the other side's going to do is going to get an expert report, a retrospective report that says opposite. The court do like a will draftsperson's evidence. So if you've got that note in front of you, that will file in front of you, it's going to make your job, not that it is your job to make anyone's case easier, but at least you'll have said what happened at the time, which is always going to assist the court.
I was going to say, with regards to our note taking, we do try to make it personal as well. So we will take down specific information, family trees, making sure that we've got an understanding of their assets, obviously not down to the exact penny, but general awareness of what they are leaving and in their estate and in the will, and ensuring that they understand that, you know, what the will does, and all of that will be held within that note. Because, like you say, I'm not going to remember in 10 years' time necessarily a conversation I had with somebody.
The interesting outcome of this case then is that ultimately your costs are borne by the respondent. Norman, how did that come about, and why has the court made that decision?
If we turn to paragraph 13 of the judgment, Chief Master Schumann explains solicitors who are will drafters are expected to disclose information about the drafting of the will. The delays in this case have been lamentable and have not helped these parties one jot in terms of trying to reach a resolution to the matter. So I think it's clear communication and adequate disclosure by probate practitioners is crucial, and it's very much expected by the courts, and failure to do so may result in being compelled to attend before the High Court and an adverse cost order being made against you personally. So in my eyes, the judgment, it's an important reminder to the profession because it notes the obligation upon will drafters and practitioners to both promptly and properly respond to these requests.
Importantly, what we're not saying here is if you take a week to respond to a Larke versus Nugus, you're going to get slapped with a costs order. But it's, as you say, a useful reminder that unnecessary and unreasonable delays, and those two words are quite challenging to define, but in such cases, there is a good chance that you're going to end up with an adverse costs order. Which kind of leads us towards the end of the time for the recording. But as I said, it's useful really to take away some key pointers, some best practice, some things to adopt in our working lives. How does the outcome of this case influence, or how should the outcome of this case influence future best practice, Shannon?
So the court's ruling really emphasises the necessity for executors or those involved in the drafting of the will to fully comply with requests for information. So ensuring that parties should provide the clear, detailed answers, and shows that failure to do so can lead to legal action and potential cost penalties.
Yeah, so following on from what Shannon said, another outcome is obviously just an awareness and the use of Section 122 summons. The case demonstrates the effectiveness of a Section 122 under the Senior Courts Act 1981, which compels a person to attend court for questioning. This goes to both the non-contentious and an awareness of what can come, but also, you know, the contentious teams to show the effectiveness of this route. So practitioners should be mindful that these tools do exist to enforce cooperation in will disputes, ensuring that the parties are aware of their responsibilities to respond to our inquiries in a timely and comprehensive manner.
I think a point to note is failure to comply with a Section 122 summons is contempt of court by way of subsection 3. So failure to attend can result in contempt proceedings being brought for imprisonment and so forth in those extreme circumstances.
And so if we're going to wrap this up into a little bow at the end of the podcast, Shannon, what is our key kind of takeaway from the case?
So in summary, the case emphasises transparency, cooperation and careful cost consideration in will disputes, suggesting that the key principles for best practice are followed, and we can ensure that we keep contemporaneous file notes to be relied on in the future in the event of similar cases.
What seems like a relatively straightforward case actually has got quite a bit of nuance to it, and it's been really interesting to go through some of that with the three of you today. So first of all, thank you very much indeed for joining the podcast. Thank you to Lucy, to Shannon and to Norman. The Today's Wills and Probate podcast is available on your preferred podcast provider. It's also available on todayswillsandprobate.co.uk. Thanks to the Forbes and Nine Chambers team for joining the discussion. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at todayswillsandprobate.co.uk and follow us on LinkedIn and Twitter.